Yes, my name is Seward Lasham.
Okay, let me take a look. Let me see if he is available. Do you mind if I place you on a brief hold?
Well, he just answered the phone, but he couldn't hear me, so I know he's in his office. He picked up the phone about 2 minutes ago, but he couldn't hear me.
Okay, let me see if I can get you transferred over. Give me just a moment.
This is Trevor.
Trevor, this is Seward Lasham.
Hello, sir. How are you?
Okay, have you come up with anything?
One second. Sorry, just needed to close my office door there. Have I come up with anything? You mean like a settlement?
Yeah, that's
Okay.
the last thing.
Uh,
Right now, as far as I'm concerned, is like I'm not prepared to go to court. Okay, I have to punt.
r-
It's like fourth down and 40. You guys are gonna spank me like a slave in a market down south,
I,
150 years ago. All you want is money. So explain to me. I'm gonna try to be quiet and let you go through the whole drill, and I hope you have a ballpark figure of what we're up against as far as monetary relief. Okay, how much am
okay.
how much am I gonna have to discount my house? How much money am I going to lose on selling my house because I have to pay this huge fine that's unwarranted?
Okay. So let me just explain something here real quick. This lawsuit is not about collecting on fines. It is a lawsuit for an injunction to get you to uh, apply for architectural approval for the changes that you made to your backyard. That's what this whole thing started out as. I understand that there are fines that have been put on your account, and if we're going to settle, that's probably something that we should take care of as well, so that you can get your account current and get things figured out. But this is primarily about complying with the CCNRs when it comes to the alterations that you made to the back of your yard. Now, if you want to make a settlement offer, um, that has to include you either uh, undoing the alterations that you made, or at the very least, submitting an architectural approval to the association so that they can make a decision as to whether or not to allow those alterations to remain. Now, that's essentially what this would be about. To avoid trial, you would have to let them know which of those options you want to take, and then we have to determine a time frame for them. And then we have to submit what's called a stipulated judgment to the court, essentially telling the court, okay, he's agreeing to do these things, and he has until this date to do them. And if he doesn't do them, then we want the court to give the HOA permission to, I'm not sure exactly what it would be. It would be something that has to be worked out, either to impose a higher level of fines or whatever it is. Now, that's how these things typically get worked out. I can't negotiate for you with the association. You have to tell me what you're willing to do, and then I can go to them and say, okay, well, this is what he's willing to do, and this is what we can agree to, and then they'd have to make that decision. So that's the way we would need to go about working this out. There's a good chance. I can't speak for them. They have to make the decision. There's a good chance that they would be willing to waive at least some of the fines if you bring your property into compliance. So that's typically what happens in these cases. offer to them, then you have to tell me what that's going to be.
Okay.
You can't go to them and say, hey, you guys, need to.
Okay. Did you watch? I requested the last time we spoke. I requested that you look at videos. Did you look at them?
I did not.
All right. So you don't want to know anything about the history with me and the HOA.
Well, I don't think it's relevant to this case. I think that what's relevant is what the case is about, which is the alterations you made to your backyard that the association asked you to apply for approval for, and you didn't. I know that you post a lot of videos online, and I know that you recorded our entire conversation the last time we spoke, and you posted that entire conversation online. I don't think that you want me to sit around watching those videos because I have to bill for that time.
Well, that's the thing. You don't really care about the truth. You're not caring about the truth. All you're seeing is a big dollar payout. All I got to do is I don't want to get cynical here. I'm trying to be as patient, but you don't want to know. First of all, the lot was built intentionally out of compliance. The lot, they know about that. They know about it. I've got letters that go back 12 years. I have a letter from Pat Pence Young that tells me that they can't approve any elevation changes to the lot. The lot was built wrong from the start. I have documents to prove it.
Let me interrupt you.
Yes, go ahead, please.
That doesn't have anything to do with this case. If you have an issue with the way your lot was built, you have to go to the developer and tell them, hey, you guys, you built this lot wrong.
Wait a minute,
You have to hold me
Trevor.
The HOA is not the developer. They didn't build your lot.
Trevor, you sent a deed. You sent a copy of the deed. And on the deed it says, the grantor hereby binds any successor to the warranty all the work. Okay? The grantor, who was the builder, Meritage, said whoever successor to me has to warrant everything, all the maps. You're throwing rules at me that are what I call a tempest in a teapot. They're little infractions that I broke. The biggest rule that I got broken, when I read the language, I wrote your whole statement. I don't appreciate you at the end saying we want to fine him to the maximum, because the more we get fined, the more we get to keep in our pocket. Now I got a picture of you. I'm on your website. I got a picture of you, and I've got a picture of Austin Ballio. Whether you believe me or not, Austin Ballio, about 3 years ago, walked onto my property. When all this started, I made him. I'm 75 and a half years old. I've been around. I've worked casinos. I've worked places. I know faces. And if he would have walked off my property and kept walking that day, I wouldn't have made his face. But he stood there like an insolent, spoiled little brat from Malibu that says, I don't have to move. I am a lawyer. So I got a really good look at his face, up and down, up and down. He even almost got me in a fight with another golfer. And the people, when he finally left, I went in the house and got a video camera. And when I came out with a video camera, him and this golfer were gone. And I asked the people who were on the tee box about 30 feet or 30 or 40 feet from me, I said, did you see what just happened? And they said, yeah, that guy came down the access easement. He wasn't a golfer. We saw him come down the access easement and walk onto your property. Now,
I cannot speak to any of that, but it has nothing.
Well, that's what happened. That's what happened. I made the guy. I had pictures of him. He's the first guy to send a letter to me. Okay? And that was like back in 17, I got a letter from him. I had a bunch of stuff and I complied with it. but when that letter was delivered, it was delivered return receipt, a green copy. There was no green copy with it. It hadn't been opened, but there was no green copy. And being out here in Buckeye, at the end of bucolic Buckeye, with a small post office, they could get away with that. All right? So I took the letter and I started looking up him on the internet. And I got a picture of him, a real good picture of him. And that day, when I came in the house, I said, where have I seen that face before? And the thing of it is, like I said, if he would have kept walking, if he hadn't have been going to stand his ground and have a face-off with me, because I was screaming at him, who are you? Why are you on my property? Okay? And that was around the time that the first letter was written. Okay? And that first letter, if you would watch the video, you don't want to watch the video because you don't want to be proved wrong. I put in a video where you put down things in your statement that weren't there. Nothing was there. The lighthouse wasn't there. All the fines were paid. And every letter, one letter you said they told him about the lighthouse. I never heard about the lighthouse until January of 24 in the lawsuit.
The HOA sent you letters before they even got us involved that said any alterations made to your backyard need to go through the architectural committee. Please.
And I got a letter from 12 years ago, and I got a witness. He won't probably, but Ed Kelly and the town supervisor 12 years ago told me you can do whatever you have to do to get your lot to drain. Now, all my videos, you won't watch them because you don't want the truth. You want to.
But I don't think that.
Well, you're saying that.
Any of the stuff that you did to your backyard has anything to do with the drainage.
Yes, it does. I had to, first of all, I had to bring in a tractor. I paid.
Okay,
I've got receipts.
That's not what this lawsuit is about. It's not about a tractor.
Well, it's not about a lighthouse. You said it was about a lighthouse, and there was no lighthouse there. You said it was about fines, and there was no fines there. You said that the HOA told me about the lighthouse in May of 21. They never mentioned a thing about a lighthouse. All they said is you're doing something, and I had a 10-year permission slip. That was the last yard I was going to work on. I had to work on 2 yards to make them drain. My house, if I show up with any document, I'm going to show up with the document for the permit for my house, and I'm going to show up with the document for the grading map, which is the master. All your little rules that you got, all these Jim Crow rules, you can't have this, you can't have that, that all gets trumped by the master grading map and the plat map for the area. And when you sing the praises, I read the whole thing, and you just keep saying how the HOA has a responsibility to their members to make everything is right and supposed to be squared away, and everything we're doing this. What the reason we're taking you to court is to protect the membership. You got an easement over here that was stolen fair and square 20 years ago, and you don't want to hear about it. If I show up with anything, and I'm going to keep appealing this, and I'm going to keep putting stuff on, and eventually, if it gets bad enough, maybe I can get one of these newscasters out here and say to safety. ABC all the time says if you have something in your neighborhood that you consider unsafe, please call us and we'll investigate. We have an access easement over here. The highest and best use is a multi-use easement for the membership. And the membership haven't had it in 20 years. It was taken away from us. And I have the plans. They didn't build it per the plans. I keep going back to this. I'm an airplane mechanic, but I have to tell anybody that I sell my house to that the house was built wrong. Don't come in here thinking that you can use the sewer system like it's a normal house, because it isn't. And I'm willing to lose money. I'm willing to lose money and sell it at a lower price to tell you that the house was built wrong. And if you're really curious, I've got about 300 videos out there that shows all the work I did on my houses for 10 years after Pat Pence Young sent me a letter. I proved to them 12 years ago that my lot didn't drain. I had a surveyor, a professional, 35 years in the business as a surveyor. And I'm 35 years working on airplanes. So we're both technical people. I don't make money by pushing words around, pushing the pencil. Okay? And going back, making statements about how the HOA is so concerned about the membership over here. The HOA was that concerned about the membership in Parcel 12, they would correct Tract A. That's my whole obsessive compulsive is Tract A's out of service. That's why I'm fighting this. You guys think I'm an oddball or something like that, or you have to get rid of her. You think this is a high stakes poker game and he's from out of town and we're going to take him for everything he's worth? We're going to take his whole bankroll? I've been struggling here, dude. I'm not a fighting person.
Can I talk, please?
Sure. I'm getting tired of talking. But do me a favor. Honor the fact, please, honor the fact that they built the house wrong. The lot is wrong. For you tell me to restore my lot. This house and this lot have been a lab experiment for me for 10 years. And I'm not getting any help. When I get a letter from Pat Pence Young that says you have to go downtown to make elevation changes, that was 12 years ago. I go downtown, nobody will talk to me.
Okay. That is, again, I think we're getting off topic.
No, we're not. We're not getting off topic. You were off topic to start with by saying there was a lighthouse on my yard. Like I said, we spent 12 to 13 minutes talking about a lighthouse. Okay, that wasn't there.
Okay, sir, I have a hearing in 4 minutes that I need to get to. If you want to make some sort of reasonable offer to resolve this issue to the HOA, I'm happy to hear it.
Well, I can't make a, okay, if you make an appointment for me to talk to an engineer downtown, because right now no one will talk to me. When I go in, the first thing I have to
I don't control the engineers downtown. I can't make an appointment for you. You have to make your own appointment.
Well, they won't talk to me.
That's not my job.
They won't talk to me because the lot is wrong. And for you to say you have to restore the lot and for the HOA to order me to restore a lot. And one last question before you go. Do I or do I not have a $100 a day fine on my account that started in October of 22? Do I or do I not?
I can't speak to $100 a day. I'm sure there are fines. There might be several because this has been going on for a long time.
Wait a minute, you're representing the plaintiff.
I am not. We did not file a lawsuit to pursue fines. We filed a lawsuit to get a court order requiring you to take down that whatever it is in the backyard that you have the chairs.
What that is that's a barrier that keeps golfers off my property. You won't come out here. Ask Austin Ballio. Ask him, say, how close you were on his property. You walked on his property 3 years ago. You walked on his property 3 years ago. How close is he to the tee box? How many times you think he gets a golf ball in his yard? When I get a broken window...
You bought that home.
I bought that home thinking that I had responsible people in the golf shop. I thought it was like McCain Republicans in that golf shop. We don't have McCain Republicans in that golf shop. We got Trump Republicans.
I don't even know what that means.
Well, what that means is this was the old guard. These were real golfers 20 years ago. But you've got young people like yourself right now that see me as a big payday. All right? I don't want to hear about the history. I don't want to know what you've been going through. I want you to restore your lot to what it was. Well, what it was it was a catch basin. It was an illegal encroachment. It was an encumbrance put on my lot. Don't you understand what an encumbrance is? When you lowered my house 2.5 inches, now they want me to tell everybody.
I lowered it.
No, you didn't. But it was lowered by the engineers out here. Okay? I was from out of town. I outbid everybody that was here. They raised the prices of the lots. They sticker shocked.
Like I said, I have my.
You don't want to know about it, right?
I have to go.
Well, this is going on YouTube. It's going on YouTube. Thank you. See, he hung up on me. He doesn't want to know the history of what happened. Okay, this is who I was talking to. This is the fellow that walked onto my property. Okay, Trevor Ash is a junior associate attorney at Maxwell & Morgan, PC, representing planned communities, condominiums, associations, in assessment recovery, enforcement, and general counsel in Arizona and California. All right, these two guys are junior members. Austin Ballio is a partner with Maxwell & Morgan, PC, and is a highly valuable member of the firm's litigation department. Austin has practiced law for more than 10 years. It will be a focus on community association during the last 4. Austin activity advises his clients on general counsel members, represents them in simple and complex litigation and assessment recovery. Austin is also uniquely positioned to recover assets out of state, including in Nevada and California. So this guy's got license in California, Nevada, and this fellow right here who just hung up on me. Okay? And as you saw, he doesn't want to hear a thing about my lot. All he wants is, we've got a charge against you. We did something wrong, and we're not going to back off. Now, he hasn't helped me a bit. He hasn't helped me a bit. First of all, he doesn't want to know that the lot was built wrong from the start. Remember these two guys. And please, I just spent all morning watching HOA videos. It's called HOA Hall of Shame. I must have watched 15 videos about HOAs. It's all about money. I've been here 19 years. For the first 9 years I was here, I paid over $21,000 in HOA fees. That was just the first 9 years. For the last 10 years, it's been almost that much because they raised the fees. And like this guy, you think he should know? You think he should know? You think the AAM or the HOA manager should have told him, hey, we're fining him over here. We got him up to almost 60,000, and now this guy wants to fine me. And they keep saying, you're return it to what it was. Restore your property. The property was built wrong from the start. All right? Nobody will recognize that. Nobody, the board or anything. But anyway, if anybody empathizes with me or is going through the same thing, watch out for these two here, Wyatt Earp and Doc Holliday. They're out for your money. Okay? I don't want to know. No, I'm not going to look at your videos. I'm not going to spend, that would cost me money to look at your videos. Any video that's an hour long, I got to charge an hour to see it. They want simple solutions. We can lie on our charge. We can put the first five charges on your summons can be all untrue. They're untrue. There was no lighthouse, the fines were paid, and there was no specific orders in any letters. No specific, nothing mentioned lighthouse, nothing mentioned wind chimes or anything. Please, watch out for these two guys. Thank you very much.